Patrick DeRay, Chief of the Bureau of Automotive Repair. I want to welcome everyone to the Bureau's regulatory workshop on exempted services and pre-service inspection procedures. We have some thoughts relative to some legislation that attempted to address this last year, those bills, AB 873 by Assemblymember Brian Jones and SB 778 by Senator Allen. Did not become law, but the Bureau felt a need to address some of the issues that we thought we could address through regulation, dealing with primarily the exempted services that are already in statute. So we have organized today's regulatory workshop with that in mind. I want to let everyone know that we last, in April, when we last kind of addressed another issue contained in Senate Bill 778 dealing with oil change service intervals. We still intend to go back to that issue, but we thought, based on our workshop in April, that there wasn't a lot of consensus and we needed to kind of deal with some of the other issues that were contained in the legislation. So that's why we're here today. But I do expect that at some point we'll, and probably following our October meeting of the Bar Advisory Group, that we will be coming back to the oil change service interval issue once again. All right, with that brief introduction, I want to let everybody know that we are webcasting today's regulatory workshop. Those who are listening in at home or at work or wherever they may be can actually participate and ask a question or a comment related to the presentation. The mechanism for doing that is to write an email through our the site that we've set up for this is bar meeting, or the address that we've set up is barmeeting@dca.ca.gov. Again, barmeeting@dca.ca.gov. All right, we have a presentation that we're going to share with everyone. Oh, one other final note for those listening in. We've passed out or distributed copies of the presentation as well as some draft regulations that go into more the exact phrasing or wording of how some of these concepts would look in our regulations if they were ever adopted. So you can get that if you're at the front table when you signed in here, or if you're listening in through the webcast. I'll tell everyone how to get there. Click on from the BAR website, which is at bar.ca.gov, www.bar.ca.gov. Click on the tab About BAR. That's on the far right of the home page. And under BAR Information, click on the Laws and Regulations. I think it's the sixth bullet, number sixth bullet down. Then under Regulations, click on Regulatory Workshops. And the first box is the materials for the July 20th, 2017 workshop today. Before we turn it over to Brian Clark, who's been our staffer working on the presentation and will give it the presentation today and has helped with some of the drafting with his legal background, the drafting of the draft regulations. Wanted to go around the room here at the table here and see if we could get some introductions of those who might be actively commenting and participating in the workshop. Starting with to my right, Jonathan.
Jonathan Morrison, Auto Advisory Services.
Mike Flanagan, Les Schwab Tire Centers.
Jack Molodanoff on behalf of a couple of organizations, California Auto Body Association and the Automotive Service Councils of California.
Elisa Reinhart with the California New Car Dealers Association.
Stan John Black with the OCA.
On.
Art Rocha with the OCA.
Tracy Renee with the Automotive Service Councils of California.
Dave Abraham, Sears Auto Centers. Mike Knudsen, Automobile Club of Southern California.
Jeff Hammer, Bureau of Auto Repair.
Brian Clark, Bureau of Auto Repair.
Sergio Morchetti, Bureau of Automotive Repair.
And we're working on getting one of the mics fixed as we speak. And certainly anyone in the audience, don't be shy. Feel free to jump into the process at any point in time. We definitely welcome all input on this proposal or these concepts. Get that mic fixed. Yeah. We can move the mics around too to make sure that everybody's heard, because it's certainly important for those listening in via the webcast to hear some of our comments. In fact, when you do have a comment at the outset, I should probably remind everyone, please just restate your name and association, just so those listening in can identify or who's making the specific comment. All right. Brian, we're going to turn it over to you. I did want to kind of, just so everybody knows, we have kind of shopped this a little bit before today's workshop. We've sat down with some key industry stakeholders who were very active and involved in the legislation last year, kind of run some of the concepts by them to help us get to the version that we have today before you. So this is not the first airing of some of this information. We did feel the need to kind of, before we went here today before you, kind of get some input from those who were very intimately involved in that process last year. So with that, I will turn it over to Brian to give a PowerPoint presentation on this, and then following his presentation, we'll open it up for a discussion for all the parties involved here. Thank you.
Once again, my name is Brian Clark. So the topic of today's presentation is exempted services and pre-service inspection. We will have a formal Q&A at the end of the presentation. However, if you have any questions or anything to add during the presentation, feel free to do so. We are at the workshop stage in the regulatory in regards to this proposed regulatory package. We're not wedded to any of the language at this point. We're seeking input, so keep that in mind when you're making your comments. We're not here to defend it. We are here to seek input and to see what you people, the people in the industry, think about it and how we could make it better. Okay, the current definition of a repair of motor vehicles is set forth at Bar Regulations Section 3303H and states repair of motor vehicles as used in Subdivision E of Section 9880.1 of the Act shall not include the repair of that portion of a recreational vehicle which is intended for human habitation and which is unrelated to the operation of the vehicle or a transmission fluid change. We are proposing to expand that definition to include additional exempted services. The list will continue to include what is existing there in regards to the portion of recreational vehicles used for habitation and transmission fluid changes. And in addition, the revised definition will exempt the following additional services from the definition. First being roadside services, which will be separately defined in a new proposed Section 3303J. The exchange of engine coolant, power steering fluid, brake fluid, differential fluid, or transfer case fluid through the designated drain or fill points, engine air filter or cabin air filter removal or replacement, positive crankcase ventilation valve replacement on vehicles manufactured prior to the 1976 model year, fuel filter replacement on vehicles manufactured prior to the 1976 model year, removing or installing tires, except where the vehicle is equipped with a tire pressure monitoring system as defined by the National Highway Traffic Safety Administration. Testing, replacement, or installation of batteries, but excluding the removal of propulsion batteries for electric and hybrid vehicles. Replacement of accessory drive belts, not requiring disassembly of the vehicle or removal of its components other than the tensioning device or pulley associated with the belt replacement.
Right. Could you also mention the fact that there are statutorily exempted services that are also going to?
Certainly. So under the statute, that's referenced in the current regulation, section 9880.1. I believe it's E as an echo of the act. That subsection that defines. That's kind of the baseline of what defines repair of motor vehicles. So it includes certain things that are included in that repair, and then it gives a list of services that are typically performed by gasoline service stations, I believe is the language, and provides a list of services that are excluded from the definition, things such as repair and replacement of tires, installing batteries, windshield wipers, things of that nature. So keep that in mind that our regulation it doesn't go beyond what the statute permits, or it cannot go beyond what the statute permits, but it can expand upon what is in there. The statute is not an all-inclusive list. It does include language that specifically states that it should not include services that are issues that things that are health or safety issues, things requiring mechanical expertise, things of that nature. Moving on to the next section, roadside services. This will be, as previously discussed, an exempted service under the definition of roadside or under the definition of repair of motor vehicles as contained in the regulation. The separate definition will be as
Advance the slide.
did I do that? Oh, I'm sorry. I did it on my computer, but not. So the proposed bar regulation 3303H will add a new definition of roadside services, and the definition will be, or the proposed definition is, services performed upon a motor vehicle for the purpose of transporting the vehicle or to permit it to be operated under its own power, and also that such services will be limited, the performance of such services will be limited to by or on behalf of a motor club holding a certificate of authority pursuant to Chapter 2, commencing with Section 12160 of Part 5 of Division 2 of the Insurance Code, or by an operator of a tow truck as defined in Section 615 of the Vehicle Code that is owned or operated by a person or entity who possesses a valid motor carrier permit as described in Section 34620 of the Vehicle Code, and is enrolled in the Basic Inspection of Terminals program as described in Section 34501.12 of the Vehicle Code. I believe that this language closely mirrors the language, I believe it was the language that was contained in, was it SB 778?
8873 initially, then SB
8,
778.
yes. We wanted to keep the language in response to some of the comments that we received last week. We made some revisions to this definition to make it more inclusive of that definition for the roadside services, the performers. To the next slide, pre-service inspection. Proposed bar regulation, there will be a new 3303S. The pre-service inspection will include one or more of the following procedures: visual inspection of the condition of the vehicle, fluids and components, retrieval of diagnostic trouble codes, testing batteries, not including propulsion batteries. Any or all of those above mentioned services have to be performed free of charge, and they cannot require disassembly of the vehicle or removal of its components, with the exception of the removal and reinstallation of a vehicle's engine air filter, cabin air filter, and caps, covers, plugs, and lids necessary to conduct the above listed procedures. The two highlighted things below, which we figured would be the most important, A written estimate to perform a pre-service inspection is not required. It's not prohibited. You can get a written estimate in either electronic or paper form, but a customer's oral authorization to perform the pre-service inspection is all that's required. And honestly, that went faster than I thought it was going to.
Nice going, Brian. Thank you.
So we'll open up to questions and comments. In addition to anything that you may bring up here, if you download, a couple days later, you're driving home and you think up something, a question or a comment, you can also provide it to me via email, or you can call me, or put it into writing and mail it.
This is Dave Abraham from Sears Auto. Brian, I had a couple questions. Number one, on the exempted services, has anybody thought about verifying and checking the air level on tires? We have customers pull up to our shops all the time and just want us to check the air pressure. I've been told in the past that we have to have authorization to do that.
To check air pressure?
Mm-hmm. And put it to the correct level.
Honestly, that was not something that we had discussed. It doesn't mean that we would not consider it, but we would have to discuss it amongst the staff and determine whether that was something that we could put into the exempted services. It may be something that we could put into it could also fall under pre-service inspection.
Mm-hmm.
There's the law. Where's the statute?
There's a section in the health and safety code that requires that if you're an automotive repair, mechanic or a shop, you have to check and inflate. That is a requirement under current law. So I'm not sure how, and I think it requires that if you don't check and inflate, there's some disclosure requirements or some admonitions you have to give to the consumer.
Right.
So I'm not sure how that would work with this. But I hear what you're saying, because some people they can just check my tire real quick.
Right.
But I think you fall into that category where you have to comply with the health and safety code. And I'm just thinking of the check and inflate stuff. Brian, you may, I don't have the section in front of me. Is that what you were thinking of? That's just a comment for consideration. It's Air Resource. It's Air Resource Board. It's a regulation, but it's based on the health and safety. Yeah, it's a check and inflate.
I'm Tracy Renee with the Automotive Service Councils of California. I just want to make a comment to that too, because that's what I was thinking about. If we're not going to have a, written authorization or writing up any paperwork, and we're just looking at these vehicles, are we still required to check the tire pressure? Because that is a separate, Air Resource Board law.
Yeah.
So.
The pre-service inspection, it's based on our BAR's authority under the Automotive Repair Act. So any other additional requirements under the law would not yield to our regulations. If it's a statutory requirement, it would not. You'd still have to perform it. It's just these specific services that we were listing would not require a written estimate and authorization before you perform that.
So we would still be required to have something in writing having to do with tire pressure.
If you otherwise had to do that, yes.
Wow. This is a first. Hello, is this on? Les Schwab Tire Centers, America's Tire, number of tire centers. We, as a matter of just routine, if someone rolls into a bay, hi, how are you? And we'd automatically check their air pressure for free.
Yep.
It's just, and it's done universally. So is the issue that we have to get a written authorization to do that now? However, it makes it pretty easy under 9880.1 does have an opening and other minor services to be determined by the bureau chief, so I would certainly think that shouldn't be an issue. And this first time it's been raised, let's add it to the new list of exemptions. If that would be okay. Any objections? So be it. Oh, I'm sorry. It was just wishful thinking, Chief.
Jeff Hammer, Bureau of Auto Repair, that's a great point. We'll discuss it and note it down and take it in advisement.
Thanks, Dave.
So I had a question on the interaction. This is Mike Knutson. The interaction between the roadside services exemption and the removing or installing tires provision in sub 8. And the question is, I mean, I guess if you're under the roadside services, then it really doesn't matter. You're still able to change a tire on the side of the road. Correct?
Jeff Hammer, Bureau of Auto Repair, that would be correct. You're enabling the vehicle to be moved off the road under its own power.
All right. And removing or installing tires is what it sounds like, not breaking it off the hub or the rim. Right? Is that what we're talking about? Removing or installing tires is just like putting the spare on. Is that what we're talking about? Or is that is that what's meant?
I think it's implying replacing tires.
So putting on the spare.
No, physically putting
Oh, okay,
tires on the
okay,
vehicle.
all right, okay. That makes sense to me. Okay, so it is actually putting a new tire on the rim. Okay.
Yeah, for that, I mean, for the exemption under the proposed repair of motor vehicles definition, the removing or installing tires, that's pulled directly from the statute.
Okay.
That's the language that they use. I don't really want to speak to how far or DC8 interprets that, because I think that's above my pay grade. But it is, I mean, we utilize that statutory language specifically so it would comply with the statute. So however that's been interpreted, that it would be consistent in the proposed regulation.
So could someone maybe address, I mean, does this mean changing a spare, or does it mean something else? It's more of just a clarification. I'm just trying to make sure that one hand's not giving and one hand's taking away. I don't think it's a problem, but I'm just asking how people thought what it meant.
Wanting to do roadside services, are they carrying around new tires on their tow trucks and stuff right now and putting new tires on?
No, but I'm just specifically asking, what does 8 mean?
Right.
Is all. I'm just curious what the drafters thought.
Yeah. I think, I mean, I don't want to go too far off, but I mean, the way I looked at it and when our discussions was, this would not, it's not like a roadside repair. It's changing a flat, taking a flat tire off. That's and putting the limited use spare or a spare tire that's already mounted on a rim onto a vehicle on the roadside. This would be more like a tire shop where you pull it in and they take, they break the bead, take the tire off the rim and put new tires on.
Okay. I mean, that would be my thought. I just was curious if that was a universal thought or if there were.
Perhaps if this language is confusing, we could work
I-
it a little bit to clarity.
It it does seem like it would have value to be able to just answer that question. We're not talking about changing a spare, and everyone just kind of understands that. So we don't have to talk about it 3 years from now when there's a confusion somewhere that probably won't even involve my client, but I was just trying to figure it out.
The intent is not to limit basically what the AAAs and the roadside service providers are doing now. We're not intending to limit it. The roadside services exemption is kind of a to provide some peace of mind.
Yeah, it's pretty comprehensive and very much appreciated and appropriate in our opinion. So thank you.
Hi, Bud Rice with Quality Tune-Up Shops. My question is, one of the benefits of an ARD is recourse. So consumers have recourse to complain if there is an issue. Is that still in effect here for all these services that are listed, that the consumer still has recourse?
Well, if there was
these exempted services would be things that would not require an ARD to perform. Because they would be outside the definition of repair of a motor vehicle.
But the consumer's complaint is my point. Can they bring a complaint with BAR for one of those services?
Yes, they can. We often receive complaints against unlicensed facilities or unregistered facilities.
Tracy Renee, Automotive Service Councils of California. On the roadside services, to permit it to be operated under its own power, and I know that's been used a lot. Is that pretty vague as far as, I mean, permitted to be operated under its own power? I'm just confused. I mean, what if it needs a fuel pump? It needs a starter. It needs a what does that mean?
Well, all right, I'll let you.
That's a good question. Every scenario is different. If it's got a dead battery and it's stuck on the side of the road, they can put a battery in it to allow it to start to get off the road. Obviously, I don't think the intent was to drop a fuel tank and put in a fuel pump if the fuel pump failed.
Which to your point, nobody does, so yeah, it's not how it works.
If a tire blows out, obviously they're going to change the tire to get it off the road, or get it to a point where they can get it winched onto a flatbed tow truck and tow it to a repair facility.
One thing, if I may, would like to first go over a couple key issues. Stan Van Vleck off of AOCA. If I can, first want to thank the chief and thank the staff for working on this. I think some of the key things that we looked at through the legislation this past year and then working this process is the importance of providing efficiency to consumers and trying to get them in a position where it's safe, but where they can still receive services that make sense in a cost basis that works. But one of the things that we looked at last year in the legislation was taking and really removing a lot of the abilities to be able to provide these type of services. And so I appreciate what the BAR is doing, and I appreciate the direction out there giving latitude to ARDs as well to be able to have that done. And it's something that as we're referencing back to the legislation, and again, the purpose of why all this is being done, one of the key purposes that BAR has is protection of the consumer and protection of the consumer's rights, both from a safety standpoint and cost. And ironically, in the legislation last year, the consumer spoke very loud. There were over 15,000 letters that came in supporting that you maintain the ability for people to do maintenance with. So the importance of having people being able to do that without being licensed, that we're not conducting repairs. And then the information is still coming in. It's almost up to 30,000 people who have now come back, and consumers have said this is what we want. And so to the point that you guys have done, you guys have said we've heard something, we're seeing it, we're trying to make that work. We appreciate that. I'm sure the consumer does as well. It's consistent with those actions. And so if we can, my compliments, and if we can, I wanted to be able to go through on the third slide, additional exempted services, just a couple key questions. As we're taking a look at and we talked about this briefly, Pat and others as we're going through this in the meeting last week, there was a reference both on the issue regarding crankcase ventilation and replacement of fuel filters, the reference to the 1976 date for vehicles. It was our understanding that came out of a lawsuit or an ALJ action. We just want to see if that's possible, if we can get a copy of that ALJ action, and then the rationale for using that. That is, we said we did that based on an ALJ action. If you could provide us the background, why that nexus happened, that would be helpful to understand. Was the case right on point and said you need to do the following, or more it was something you guys inferred that was the case? We'd just like to understand that better.
The ALJ, Jeff Hammer, Bureau of Auto Repair, the ALJ in that case, the respondent ruled or stated they replaced fuel filters and PCV valves on older vehicles. And the older vehicles weren't defined, so the judge ruled and dismissed the citation on that. We picked 76 for a couple reasons. One reason, the original statute indicated service is normally performed by gas stations, which was prevalent in that time frame, and that was the beginning of the actual emissions testing. Like Brian said at the beginning, these are just kind of a starting point. We're looking for feedback. Any suggestions would be welcome, and we'll take them into advisement.
Thank you, Jeff. That's very helpful. I appreciate that. And that helps us give us that background. So thank you.
Yeah, I mean, the 76 model year, that's mine. I utilized that language. It's from the emissions testing statute, and that's the cutoff, basically. Anything 75 and older is not subject to emissions testing. And, you know, the PCV valves and the fuel filters, we saw those as being part of the systems that would either, you know, directly or indirectly impact emissions, and the testing of that. So that's how we came to that, you know, in terms of a limiting or a cutoff for the testing.
That's helpful to understand. What we'll do is we'll go back at that and look at that with that in mind and see if we have any comments. And if so, obviously we'll get them to you. So it's helpful.
Yeah, and in regards to your early question about getting a copy of the decision, I don't think that should be an issue. Those things are like any court decision. It's public record. I don't know if there's a database for it, but I mean, I'll double. You know, I can provide a copy of that. I have a copy of it.
That'd be great. Thank you very much.
If you would like to, I mean, I'll try to remember. But if you wanted to shoot me an email just as a reminder in the next day or two, I can turn it around.
Happy to do that. Thank you. And then the next question actually really was a comment, and the last bullet that dealt with removal of the belts. Want to say the last bullet relating to the removal of belts. There was the issue about what disassembly meant, and so it looks like you folks did a good job going at that. We're going to go back, take a look, because this is the first time we've seen that new change. But it seems to make sense. Again, we'll go back, we'll give you comments on it, but I want to say thank you. That looks like a thoughtful way through that issue, but again, we'll go back and confirm.
That was brought up in the last meeting a week ago, so we tailored the language a little bit to try to clarify that.
Great, so thank you. Yeah, I brought it up, so I appreciate it, because it's one of those where it wanted to make sure what was meant, and it helps us get on the same page the way you put it together, so thank you. The final question I have is, Jeff, a little bit ago when you were talking about the unregistered facilities, you talked about you folks receiving a lot of complaints about unregistered facilities from consumers. If we can have more information on that as well, because you said it's pretty common. How common is common?
I don't have exact numbers, and I don't know if a lot was the right term. We do receive them. We investigate them. I don't have the exact figures of how many come in.
Okay, I just want to make sure, because you said a lot, and I just want to make sure we go through. Okay, fair enough.
I don't have a number, so maybe a lot was
Fair
right.
enough. Okay, fair enough. No, thank you. That's it. Thank you. And again, my compliments to all of you for what you're doing.
Thank you.
Jonathan Morrison, Auto Advisory Services. I just wanted to chime in. Let's take a step back and make sure we recognize what we're doing. You talked about complaints about unlicensed activity. What we're doing here, I believe, is clarifying the exemptions from the repair of motor vehicles definition from the Automotive Repair Act, right? Which we have regulatory authority to proceed in that area. But these are all areas where this activity would not be subject to Bureau of Automotive Repair jurisdiction. So you can get complaints about unlicensed activity or unregistered repair facilities that are acting within this area, but you wouldn't have any authority to enforce a law, because the standards under the Automotive Repair Act and the regulation pursuant to the Automotive Repair Act would just not apply to this activity. So kind of going down the list, there's a couple things. Just want to take a step back. Let's make sure we understand some of the real world implications. There is an exclusion from, statutory exclusion from the definition of repair of motor vehicles for repairing tires and changing tires. So there's not really, I think, anything new there. It's pretty broad. As we get to engine air filter or cabin air filter removal or replacement, now there is an exclusion for air filters in general, but I think at the time that this exclusion was established, you really didn't have cabin air filters in the sense you have now. In a lot of vehicles, those cabin air filters are in the glove box, right? So now you're going to have unregistered facilities kind of digging through there to replace that. Is that something we want to do? Let's just make sure we're going in eyes open there. Likewise, getting down to testing, replacement, or installation of batteries. excluding the removal of propulsion batteries for electric and hybrid vehicles. Well, I think most people are thinking, under hood battery, right? Your primary ignition battery and then such. But you have supplemental battery systems too, and a lot of those are going to be inside. Sometimes you have to tear out the seat and such to get down to replace some of those. So I think some of these exclusions might be a little bit overly broad, just based on if we're thinking of 1980 model year vehicles as opposed to the newer vehicles we have today.
Thank you, good point. We'll note it down and we'll discuss it.
Yeah, with the batteries, I think our focus mostly was on, when we were looking at is the propulsion batteries. Those, they're much larger, more complex. You have the greater potential for injury or death if you don't handle it properly, or this potential hazardous fumes or liquids can be released from them. I know that there's
the acid-lead battery fee battery over 6 pounds, right?
Prototypical thing you would think.
Right.
Yeah.
But I think, for instance, you have a great, kind of a savings clause for replacement of accessory drive belts. You have not requiring disassembly of the vehicle or removal of its components. Perhaps that condition could be applied to the replacement of batteries, because, again, some of these there is going to be tear down required to replace them. And do we really want to make it so that somebody could, carry out the seat to dive into replace a supplemental battery without needing an ARD registration?
Sure. Good question.
All right.
If I may, I'd like to answer a question Jeff Hammer, Bureau of Auto Repair. Stan asked earlier.
Yes.
Just handed a sheet of our stats here. In the fiscal year 16-17, we received 339 allegations of unlicensed complaints.
And of those allegations, how many were found to be valid?
That, I don't have that information. Those are just the complaints we received.
Thank you.
Just a comment with regards to number 8. What do they call it? A walk-off home run. Congratulations. That really just captures the issue that's been around for a long time. And thank you very much. That's a greatly improved number 8. Really appreciate it.
Thank you.
Jack Molodanoff. I wanted to go back or go to the pre-inspection section and first say thank you. I know this is going to provide, I think it's a game changer, and I think it truly does provide a streamlining sort of regulatory relief for the industry, especially on these free services that happen very quickly. And my comment is with regard to you've tailored it as a pre-service inspection. Now, some inspections are not necessarily pre-service. A customer may come in and have a particular requested particular repair. So let's just say for a tire, and then the shop provides a free multi-point, or they call it a free service, just an inspection service. So, in that case, a customer does pay for the tire, but the service there's no charge for it. And that's because the car is going to be lifted on a hoist, and they're looking, they're going to change a tire, and they may see something visual there. There's something wrong. There's leaking oil. Something's wrong. I'm just wondering whether calling it a pre-service inspection is that set in stone? Would it be? It's really like a service inspection. It doesn't necessarily have to happen right up front. It could happen after, the repair or during the repair. So is that something that we can discuss? Because
Jeff Hammer, Bureau of Auto Repair. The point of the pre-service inspection is to let the facility get a good look at the car without having to write a written estimate, without having to get a signature. In your scenario where they're working on a tire or something and they authorize a multi-point inspection, I'm assuming there's already paperwork in place,
Correct.
which would allow them to check whatever the customer authorizes. So if they authorize the complete multi-point, which is removing tires, checking brakes, whatever is listed on the sheet, then so be it.
There'll be occasions where the shop may, have a specific repair, and I mentioned the tire, whatever the service is, they'll get authorization for that, and then include an inspection, or they call it maybe safety inspection, multi-point inspection. They've got a service they provide, and sometimes they don't. It may be 121 points, but they don't want to list all 121 points because every car may be different. So they call it a multi-point or just an inspection, just to be safe. In that case, the customer would authorize it on the estimate. It would be a written estimate authorized, but in the estimate they won't have it all spelled out. In other words, they won't list the 121 points, because my understanding is under current law, the shop needs to at least list the items that they're going to diagnose, right?
Correct.
Is
The
it under
customer
current
needs
law?
to know what the shop
Exactly.
is going to do their vehicle, and then when it's all said and done, they need to get some kind of documentation showing
Right.
what was inspected and what was found.
What I'm suggesting is if this was, if it was possible that if they list, a multi-point, rather, would this, trying to think of a way to capture that particular issue that's taking place right now, because a lot of shops get caught up in this 121 points or 29-point inspection.
You don't want to have to list every.
Well, no,
little
because every
service
vehicle is
on the-
different, right? And they don't want to be caught with a gotcha where they get caught up and they say, well, in this car they only had 28 points. You couldn't have, 29 points. So I'm just wondering whether are you set in stone calling it a pre-service inspection? Why couldn't it be called like a service inspection? I'm just throwing that out as an idea. I don't know what the downside would be or the upside, but I just wanted to throw that out.
I think we just did it. I mean, one of the ways we did it is so it distinguishes it from, pre-service as opposed to the actual services being performed. But I guess you could also look at it as in terms of, like Jeff said, it's to give the repair person an opportunity to look at the vehicle and determine what is or is not wrong with it, without taking things off or pulling parts off of it. But like in your situation where you said they may be doing some other repair, and then come across something, and then they could you come in for a tire repair and they may see something and then say, let's do a diagnostic trouble code retrieval, and they could get an oral authorization on that. And it would be in the middle, but it would be, I guess, a pre-service in terms of pre-servicing of whatever the diagnostic trouble codes to correct that actual service. But, I mean, also I'd like to at least the way it's written right now, is these things are not, I mean, there's no timing component to this. So it's not like before you do anything else, you can only do it at this, when they first pull in, or, you can only do it in the parking lot or within 5 minutes of the car getting into the bay. There is no, I mean, as long as those, like you said, like a 120 some odd point inspection, I would say as long as it meets the definitions of those three things, if it falls within that, and you describe it to your customer in a way that you're giving them a full, that they can make an informed decision as to whether or not they want that, then the written estimate would be sufficient. We're not wedded to the term pre-service inspection, but we would like to be able to distinguish it as to other services, or at least in terms of this is an opportunity to have like I said, the repair person look at the vehicle and get an idea as to what is or is not needed to perform repairs.
No, and I understand pre-service just sounds like it's the initial, and you just said it could be during the middle of the process, and I just wanted to have
Well,
that
I just
discussion.
pointed that out in terms of the way it's written right now. I mean, I guess if it was an important thing or something that was determined to be needed, we could add a time component into it or a restriction. But I mean, the way I look at it is, if you're doing something, if you're focused on one thing and you see something else and you could, serve that customer and provide customer service by doing something that would meet the definition of a pre-service inspection. You shouldn't have to, start over. Okay, let me pull this out and start it all over again.
Once the estimate is created, then this kind of goes out the window. you get authorization to look at the car, diagnose the car, or repair the car. This, like I said, is the opportunity for the repair facility to look at the car, create one document for the customer to authorize rather than having to go back and forth, upselling an air filter, a cabin filter, whatever the case may be.
I just see this is going to be a new term of art, so I think they're going to do away with the 121-point inspections. And when the consumer comes in for a service, an oil change, or whatever they come in, they'll say, "We'll just give you this pre-inspection service, pre-service inspection." And that,
Or like a diagnostic inspection
well, no,
or
it's
something
not,
like that?
no, because it's a visual. We're limiting. We're not diagnosing here. We're just kind of giving a call it a pre-inspection service. We're just throwing it out just in terms of the timing. It just sounds like the intent here was more before, but then I heard maybe during the service. Like I said, so a customer comes in and then something happens in the middle of, you visually, you see something, you pick up something.
If you have an estimate, let's say, to do whatever, and you have the car on the rack and you notice the CV boots are torn, it's got an oil leak, then it's just as it is now. You can sell it to the customer and get their authorization and proceed with the repair.
But technically, when you start, under current law, when you're doing a diagnosis, you're looking around, I thought you had to have authorization. You can't mine the car right now without authorization.
If you're removing the wheels, you need authorization.
Yeah, but you lift it up and say customer comes in and they're just getting, a service. They're going to pay for a service. Like I'm going to go on a trip with my family. I need a quick oil change and, take a look at it, make sure nothing else is wrong. That's what a consumer would generally say, right? Okay, they do an inspection or, some sort of inspection. I'm just wondering if this would fit into that category. That's what I'm asking.
Yeah, I understand. Like I said, I think if you have the estimate in place, then this is before. Like I said, this is an opportunity to look at the car, gather all your facts, what oil you're going to use, does it need an air filter, are the fluids good, the things you can see visually without disassembling it, short of the cabin filter and the air filter, and then you can present your customer with one estimate and then move forward.
I think it's really good, so thank you very much for working on this.
Yeah, likewise, this is Jonathan Morrison. The way I see them, most of my clients are new car dealers, and the factories are pressuring them to go this way. There's consumer demand to go this way, but the whole idea is the customer wants to get in and out of the facility as soon as humanly possible, and the way that this would allow, and it's already happening in the industry. You have the drive up. You got the the mat that you drive over that checks tread depth, that checks tire pressure. You can check electronically visual, an alignment measurement. You can potentially check tire pressure even if you're doing it manually. So there's a lot of things that you want to be able to do to catch some obvious gotchas that the customer needs to have this fixed. And the way the system works now, it's a closed loop system. You can't check any of this unless you have an estimate generated, the customer's authorization to proceed, and that's going to take place right before the customer leaves. And then in order to proceed with, let's say somebody has bald tires, you can catch that up front without needing to and when the customer's in there signing the actual written estimate, you could have the diagnostic listed on that written estimate. You can sell them a new set of tires, or at least make them aware of the fact that their tires are low, or their tires are bald, without having to chase down the customer and generate a revised estimate and get their authorization if you can get a hold of the customer, right, who's at work at that point. So I see that as a real benefit, but I also have just some concerns, and I don't know if this is a matter of best practices as I'd advise my clients to do if this were to take effect, or if you want to, if it's something that we'd want to put into the regulation itself. But a lot of times people lose sight of the contractual element of our documentation process in California. In addition to the legally required estimate generation and authorization, you also have a binding contract, and this allows for that kind of contract to take place orally, which is great. But what's that old saying? Like, a verbal contract is as good as the paper it's written on, right? So having something where the findings as a result of that pre-service inspection are recorded on the actual written estimate, that's something that I'd probably recommend to my clients to do to protect themselves. Also, you have the terms on the back of your repair order, we call it backer language. That's all stuff that clarifies the obligations and the responsibilities of the parties. And I'm a little bit nervous if we just exempt all of that, and then there's going to be even more misunderstandings as to what what the obligations are going to be. Just food for thought out there.
In terms of what you were saying in terms of the contracts, one of the basic elements of a contract is you have an exchange of goods or services for some sort of consideration, either some other type of service or good that you're trading in kind, or usually it's money. But if you don't have consideration, then there's no contract. And this is what we're performing this free of charge. So I don't think that would really be too much of a concern. If you're performing the service for free, or the free service inspection elements for free, then I don't anticipate any contractual issues coming up as a result of that.
Well, I mean, it's a verbal contract, but absolutely there is the opportunity to inspect a vehicle is consideration in and of itself. I don't think there's any doubt as to that. But it doesn't necessarily need to be right.
There would be no exchange on the other by the consumer giving anything of value for that.
The opportunity to sell and inspect a customer's vehicles is
without paperwork and
absolutely, and that's fine. I mean, it's not that this would take away the legally binding aspect of that contract, or the customer is giving permission to the repair facility to inspect the vehicle in return for the repair facility. Again, peppercorn consideration is sufficient to have that opportunity to potentially sell or at least access the vehicle. It's an opportunity they otherwise wouldn't have the ability to experience. But again, I think that's beside the point. I think that there's a contract, but unless you have something documented in writing outlining the terms of the service, then I think the facility is going to be at risk. So I mean, that's again as to whether or not there should be a mandate to record what was inspected on the written estimate and the findings of that inspection. If you how do you do it now? You generate a written estimate, you get authorization, you spell out on that estimate what you're going to be inspecting, and then you record the results of that inspection either on a revised estimate or the invoice, right? That's kind of how you have to do that now. This basically if you're going to put it in writing on the written estimate, it would just move that a step forward. And again, I think that's what I'll be recommending to my clients if this were to.
Yeah, just for clarity, there's no prohibition against doing it the way things are. The status quo is now. If you want to continue doing it that way, or develop a best practice, but I mean, like you said, if you wanted to include it on the invoice that you provided at the end, that may there would be any issues with that also. Any other questions or comments?
thank you, everybody.
I've got one last one.
Okay.
Job well done. I think this has been a thorny issue on a number of levels, and well done.
Hold on.
Okay, we have a comment that came through the webcast.
We had one comment that came through on the webcast or online. It says, as professionals facility, the vehicle must be inspected every time, especially when there is a liability issue. It is unethical to let the vehicle drive off without at least a safety inspection.
Okay.
Thank you for the comment.
Jeff Hammer, Bureau of Auto Repair. I think when you're working on a car, if you see an obvious safety issue, you got to tell the consumer about it and document it down. I mean, if the tire's ready to blow out or something like that, and you don't say anything, I mean, you're just asking for trouble. So obviously, any safety issue you would want to document and inform your customer.
Jeff, I always known you were the ambulatory encyclopedia quoting the 1976 case on positive crank rates ventilation. Hats off, man.
Thank you.
Well, thank you all. I think, are there any other comments? I'll open it up one more time. Okay. And as Brian mentioned, this is not the last opportunity. If you think of something as you're driving off today or in the next few days, feel free to send your questions or comments to his contact information. The phone number and email are provided there on the presentation. Thank you. Oh, one
Oh yeah, what's the timeline?
timeline?
3 years.
Wasn't someone tracking my John Gallo left earlier, but he said it takes about 3 years to get regulations through. So I don't know if I'll be here then, but we're going to try and expedite this as much as I would say sometime next year. These things take a long time. We have a very lengthy review process that includes not just internal to our Bureau of Automotive Repair and addressing all the interests from all the different parties there and all the different units, divisions, staff, managers, but also once we get through that process, going to our department, our legal office, our budget office, everybody looks at it from the dollars and cents, the impact on industry, impact on consumers, all sorts of things. Then agency, and then ultimately OAL, Office of Administrative Law, which will begin once it gets that far, assuming something like this gets that far. We do a 45-day public comment period. That's a more formal comment process. Doing workshops and meeting with those impacted by regulatory changes on the front end is so much easier because it does pave the way for a smoother regulatory process with OAL and others. But we hope to see something probably midpoint next year. My guess is just a wild guess. We will try our best to expedite it, basically with all of the comments that we've received and will continue to receive throughout the process. But obviously, I think it bears saying our legal counsel wanted me to make sure that everybody knew that nothing is binding here. We are committed to try and push something through that addresses as many of the issues we've heard were out there and that were attempted to be addressed in the legislation last year as it relates to the 9880.1 of the Automotive Repair Act. So I think we've done, we think a pretty good job trying to address those issues without having to see another bill being introduced on this issue. Mr. Flanagan can attest. He's been working at this for.
So he doesn't skip out. Dave Abraham, thank you very much for bringing up the tire pressure issue.
Sure.
Totally missed, but you're right on the money. Thanks.
So with that, we will go back and look at some of the language that we've drafted and take back with us the comments that have been made at the workshop today. We'll look at start putting. Well, we've already done some of that. You've seen the draft language, making some changes to that, and then we'll start moving it through our legal office and others at the Department of Consumer Affairs. But and I don't know that it needs to be workshopped again. I think you heard. We will probably just come back and say the comment that was made with respect to checking tire pressure. We accepted that, or if we didn't accept that, we'll come back and say that with. That was the only one I could think of off the top of my head, but we'll do that with each of the proposals or comments that came up in relation to the current draft that's out there.
It's much easier to change things based on the input that you have provided us at this point. Because once we file the notice with the Office of Administrative Law, we go through the public comment period. If If we make any type of changes, then we have to go back and send it out for another 15-day public comment period. Where at this point, we can make the changes without having to go through those formalities. So, I guess that underscores, if you have comments, if you think that we can improve this in any way, please at this point provide that to us because it'll speed the process along.
Is there any concern that a couple of sections, I think, or at least one of the sections here is proposed to be amended to the electronic authorization and estimate regulation? I guess we just wait for those to be cleared before these would be formally proposed.
Well, I utilized the proposed revisions when I drafted the updates to that. I utilized what we are going to be submitting to OAL, assuming that it's going to go through. That one will go through before this one will, so we'll have a little, we'll know if it's going to go through like that. But yeah, you're correct. I noted it in the draft text that it contains revisions to that. And I also think that the pending one for the mobile automotive repair dealer advertising package also has some impact on this in terms of it's just not substantial numeration, I believe, for the definition, for the basic definition statutes at the beginning. But things can change like that. But it probably, stuff like that is not significant changes. But we would. Note that.
Yeah, I just worry because I suspect the electronic estimate and authorization regulations, I suspect there's going to be substantial comments from all various sources, and that could potentially go through a number of 15-day changes after the initial 45-day set, and that could have the secondary consequences of delaying this. But I will leave that to your case.
Sure. Yeah, the whole concept behind that, at least, I guess in terms of the limited focus of hold it in with this is the authorizations that now that are written in writing can be they'll still be in writing, but they'll either be in a traditional paper or an electronic format, which I don't really think would impact that because I wrote this specifically so that it would fold into that. So if you wanted to get an authorization, the written authorization is either in writing or it's electronically, but it's still written in language. And we did do some changes when before it was approved to underscore that it was so I think initially we had the language saying either electronically or in writing, which then we revised and so it's in writing, but it's either in writing, either in a paper or electronic format. To clarify.
Yeah, these are more technical APA issues. So.
Yeah, the lawyers brought it up, so we revised it.
Okay. Anything else? Well, thank you all for being here today. It was actually faster than we had scheduled for 2 hours, but I think we're until close of business, so we're very thrilled that you had as much input into this process as you did today. We will keep everyone apprised. Please make sure if you didn't sign in and you want to get information relating to this specific proposal or any of our regulatory proposals, make sure we have your information. Thank you all. Have a good rest of the week and a great weekend coming up.
Thank you.
Thank you.